All rise. Court is now in session.
Thank you, folks. Please be seated. Please be seated. All right. When we started this case, folks, and just to be clear, we are back on the record. Let me get my computer set up here. We're back on the record with everyone present in the courtroom. It has been a very long day. This is 22C7. Before the court took a break to hear another very brief review and review the evidence, court heard summation. The summation presented by the plaintiff cited the case McIntyre v. Jones, found at 194 P. 3rd, 519. The 2008 Court of Appeals case. You know, the court is always looking for guidance on these cases, and it's a defamation case, but it certainly gives a thorough analysis of what is protected speech and what's not protected speech. And that, of course, is great concern to the court because of the nature of this case. This case involves two bloggers, two YouTubers. Admittedly, I don't know that much about YouTube except what's been presented before me today. The court heard quite a bit of testimony. We accommodated the extraordinary length of this case. We were set for 3 hours. We started after 9 this morning, but it is now 4:06, and we've squeezed this case in between the other court's settings to hear this case. The court first heard from plaintiff Vanessa Walsh, and Ms. Walsh testified that she was a creator of a YouTube channel that had content about true crime. She explained to the court that viewers can leave posts or tag the creator. Those are akin to direct messages. That she first became acquainted with Ms. Oriani in this case. Through a post back in December of 2020. And that it was a post regarding the Christopher Watts case. Well, it's not relevant to go into the content of that case. That is what originated this series of events. She indicated that she contacted Ms. Oriani back on August 6th of 2021 for the first time. And since that time, they had contacted each other additional times. But then in September of 2021, those conversations turned from friendly to kind of a shift in attitude. That the defendant, Ms. Oriani, had a blog that the plaintiff believed was in poor taste, that she eventually spoke in November. When they spoke in November, she had tried to fix this, was not able to. As things continued to escalate, in December, finally on December 21st of 2021, she blocked Ms. Oriani. She indicated at that time that she had watched a live broadcast in which Ms. Oriani got upset. She was crying on the broadcast. And since that time continued to escalate her behavior. Ms. Walsh believed that Ms. Oriani had personal information, medical information that she was going to disclose. She had placed a picture of Ms. Walsh's husband in an advertisement on the YouTube channel, a teaser, and at one point had said in Exhibit 14D, "Do I have your attention now?" Ms. Walsh indicated that these continued and repeated contacts with Ms. Oriani caused her a lot of stress to the point that it affected her health. It caused her blood pressure to increase. It caused anxiety and insomnia. That she was fearful for her daughter. Because it's not just one person, it's the urging of other people as well. Next, the court heard from two associates of Ms. Oriani. The court first heard from Sarah King. Ms. King arrived from Iowa with Ms. Oriani. She met Ms. Oriani through a true crime channel. She's a personal friend of Ms. Oriani's. Indicated that she and Ms. Oriani had arrived on Friday, and they came to see Jamie Abeda. Ms. Oriani was staying with Ms. Abeda, and that Ms. King had helped serve papers for Jamie Abeda on Sean Walsh. The court then heard testimony from Jamie Abeda. Ms. Abeda's testimony was that she drove Ms. King to serve the subpoena. She had hired Ms. King to serve the subpoena. She indicated that she paid was going to pay Ms. King $50, although Ms. King testified she had no idea how much she was being paid. Ms. Abeda was aware that the subpoena had been quashed and had been told so by Ms. Oriani, at least as far as the minor child goes, but had not served the subpoena on Mr. Sean Walsh in a timely way. Rather, this was being done the night before the hearing. And finally, the court heard from Ms. Oriani herself. She indicated that she is from Columbus, Ohio, that she's been a resident of Ohio all her life, and that she started blogging in March of 2021. That's when she first went and did a live video on YouTube. that her testimony really strayed from the issues before the court, but the gist of her testimony was that she'd never met Ms. Walsh, never threatened her family, that being the family of Ms. Walsh, and did not believe that the protection order should have been granted in the first place. And repeated that as well in her summation. In Ms. Oriani's summation, Ms. Oriani talks about the first prong of the test, which the court had read to the participants earlier, and that is under 1314-104.5, the court needs to find that one of the categories, that there's an imminent risk of harm to prevent, assaults or threatened bodily harm, or 2, to prevent domestic abuse, 3, to prevent emotional abuse of the elderly or an at-risk adult, to prevent sexual assault or abuse, or number 5, to prevent stalking. The statute providing for permanent protection orders, which is 1314-106, has the court re-examine prong number 1. Okay, because this time the evidence needs to be subject to a challenge of cross-examination. So while I can take judicial notice of the application and motion, the court needs to take a look again at those reasons for a protection order. But interestingly, it does not require a finding of imminent danger in order to have a necessary prerequisite for issuing a permanent protection order. And that, of course, is, one, we were talking about it in January, and now it is here in March. But I examined those facts on the first prong to make sure that there were grounds constituting good cause for the issuance of a protection order, and that 2, unless restrained, the defendant will continue to commit such acts or acts designed to intimidate or retaliate against the protected person. So we've got a 2-prong approach. And before and after, which has been emphasized over and over again by the defendant, is a point really well taken. What was before the court at the time of that first hearing to justify the protection order, and then what's gone on since then? Well, we're going to take prong 2 first. Okay. Frankly, folks, all hell's broken loose since the order of protection was issued in January. That order of protection was issued on January 13th of 2022. I have a return of service indicating that it was served upon the defendant on the 17th of January in Iowa. And since that time, there has been an extreme escalation by the defendant. With allegations that not just once but twice that order of protection has been violated. Since that time, in reviewing the exhibits that have been admitted and let me go through those with you. The court has admitted Plaintiff's Exhibit 2A, 2B, 3A, 6A, and now we come upon some weird numbers, 7, 2A through 7, 2E. So we have A, B, C, D, and E, 8A through 8G, and 10A through 10H, all of which have been admitted. And since that time, the situation has greatly escalated. And had the court had that information beforehand, I would have definitely said under 18.3, 602, 1B and 1C. There were grounds for issuing the protection order. 1B talks about a credible threat to another person. And seeing and I don't care if it was a Nerf gun or not, being repeatedly fired and practicing aim, the court was greatly alarmed by that, and do find that would cause a reasonable person under the totality of that conduct, fear for their life and fear for the lives of their loved ones. The court finds by a much more than a preponderance of the evidence that unless restrained, these acts are going to continue. They're going to, similar acts are going to continue, or maybe different acts designed to retaliate against the protected person. Okay, but that begs the question as to prong number 1. At the time that the court issued the protection order, and it was this court that issued the protection order, what was presented? Well, frankly, the defendant herself talked a lot about that application. And at the time, at the time of that application, the court knew several things. The court knew that the plaintiff had threatened to divulge medical information about the plaintiff, had put her picture, or put a picture of Sean Walsh in the ad, a teaser for the Christopher Watts case. Had indicated that she had become so alarmed with the repeated tags and postings that she had to let her daughter know that if she would see this person come to the home, because the person had threatened to come to her home, to not let her in. And in reviewing the exhibits, the exhibit that caught the court's attention was the one that said, "That'll get your attention," or words to that effect. That's simply code for, "I'm trying to cause you emotional distress." There is no other legitimate purpose for these items than to cause emotional distress to Ms. Walsh. These are not this is not issues of protected speech under McIntyre v. Jones or any other case. While the two parties are limited public figures, that does not create open season on their private lives. So it brings the court back to brings the court back to 183602, subsection 1C. A person commits stalking if directly or indirectly through another person. The person knowingly, repeatedly follows, approaches, contacts, places under surveillance, or makes any form of communication with another person. Okay, well, here what we have both repeatedly contacts and repeatedly makes any form of communication, because whether it's a direct telephone call, whether it's a tagging, that is contact, it is a form of communication. So repeatedly follows, approaches, contacts, places under surveillance, or makes any form of communication with another person. A member of the person's immediate family or somebody with whom the person has or has had a continuing relationship in the manner that would cause a reasonable person to suffer emotional distress, and does cause emotional distress. Well, I do find that Ms. Walsh has testified quite credibly, and frankly is the only credible witness here today regarding her level of emotional distress. I find her testimony at the temporary orders hearing credible, and the testimony at the permanent orders hearing credible. And finally, she need not show that she received professional treatment or counseling to show that she has suffered serious emotional distress. So I do find that prong number one, by a preponderance of the evidence, was met at the time that the court issued the temporary order of protection. I don't find it relevant to the court's consideration that there were no direct threats made by Ms. Oriani, especially as the behavior escalated. Under 183602 2B, under the credible threat definition, credible threat means a threat, physical action, or repeated conduct, emphasis on repeated conduct, that would cause a reasonable person to be in fear for the person's safety or the safety of their immediate family. And the last sentence is, the threat need not be directly expressed if the totality of the conduct would cause a reasonable person such fear. And the court does find that the totality of the conduct does cause a reasonable person such fear. And that is the credible threat that resulted after the situation escalated. So at this point, the court now believes even stronger than I did back in January that a protection order is necessary. I did grant this order of protection under the guise of 1C originally. If examining the facts again today, I find it even stronger under both 1C as well as 1B that it is necessary. Counsel, are there any further findings that you are requesting?
Your Honor, I don't request any further findings. I do have a question regarding the language on the protection order, because Ms. Oriani stated in court both while she was testifying and in her closing that she has been in perfect compliance with the protection order in this case, and that it has been easy. And it seems as though she might think the protection order only requires her not going near Ms. Walsh, and I would appreciate if the court could add some additional language.
All right. Well, I think it's important that I don't make any ruling regarding or any judicial finding regarding whether or not that temporary order of protection was violated. I very well could be the finder of fact in a court trial that's held. This is a very small jurisdiction in a big metro area, and I have a criminal docket. You saw me doing one this morning before you came in. So let me add some additional findings and see if that takes care of this. Ms. Oriani, I don't find your testimony credible. I found your testimony to be at many times incomprehensible and wandering, and that there is a definite fixation that you have on Ms. Walsh, and it's a very unhealthy fixation. That there appears to be the motive here, and I heard quite a bit when I was commenting during your testimony. That was really for your benefit, for your ears. That what I was hearing from you was simply more motive about this passion and that you had for Ms. Walsh, and an extreme interest in what was going on with Ms. Walsh. And it's important that now that the order of protection will be made permanent, that you don't violate it. That this seems to have been caused from maybe some hurt feelings that Ms. Walsh had not wished to follow you or to associate with you, and that led to this stalking type of behavior. But now that the order of protection has been issued, it's important that you understand that you are responsible for following the order of protection, and that third-party contact especially not be practiced, because third-party contact is a violation of this order of protection. And I'm going to leave that up to the police and the district attorney's office to figure out whether or not they believe probable cause exists. But I can tell you, I did not find Ms. Abeda's testimony or Ms. King's testimony credible either. That there was nothing about what happened in the serving of the subpoenas, and there were 2 subpoenas served. I don't find that it was credible to assert anything, but that was done only for the purpose of harassment. That was done, there's no legitimate reason, first of all, for the minor child to be served. I quashed that double check my date on that. I had quashed that protection order back on the 20th of February. And if I'm looking at a calendar,
it was quashed on the 28th of February.
Thank you. My contacts are starting to stick a little bit. So the 28th, so that would have been, yeah, because the 20th was on a Sunday. A week ago today, there was no legitimate reason other than to say, ha ha, I'm here, and I know where you live, and I'm out to make sure that that I have your attention. I think those were the words. I have your attention now. That was in Exhibit 14D, that intent to inflict more emotional distress was there. And certainly it was not timely filed on Sean Walsh either. And so it's important that you and your associates understand that that's going to get you in trouble. I find that was done at your direction and is not appropriate, and in the future will get you in trouble. Okay? Again, I can't emphasize anything more to you than contact through third party is contact. Ms. Oriani, do you have any further findings that you wish me to make?
No.
All right. Well, then I'm going to instruct the clerk to prepare that order of protection.
Same as the original.
Same as the original.
is the permissive protection period, and it's the same as our calculation as the original. So this is your permissive protection period. It's the same protection period. It's temporary. It's all the same exact information. So I got 3 copies for this. And then this is
All right. Ms. Oriani, I'm going to let you go ahead and depart first. Let me just say to both parties, now is the time to let this go. Let's de-escalate this situation. There is plenty of room out there on the YouTube scene for both people to have their own blogs, stay away from each other, to not communicate, and to just carry on. All right? So let's have that happen, okay? I also want to let the parties know regarding today's hearing. I was acting as a county court magistrate, and under the Colorado Rules of Civil Procedure, Rule 411 govern, as well as Colorado Rules of Magistrates, Rule 9. So any notice of appeal needs to be filed within 14 days from today's date, and an appeal bond will need to be posted. With that, I'm going to send you on your way. Ms. Oriani, you can go ahead and head on out. I'm going to instruct the plaintiffs to stay another few minutes and to just watch outside to make sure that there's no incidental contact. Okay? Safe travels back to Iowa.
Ohio.
Ohio.
Go Buckeyes.
All right.
Ms. Oriani, are those your things?
Oh, yeah, thank you.
All right, and folks, you can go ahead and just go on outside and I mean, it just takes a second here to get down those stairs. It's such a small courthouse, and we're right by the door, or right by the stairs. So then you can just make sure that Ms. Oriani and her associates have cleared the area before heading on out.
Thank you.
We don't want you